When discovery is completed and we've had our case management conference, that happens before discovery is completed, but at the case management conference we have the lawyers present that will be trying the case, and we set a trial date, and that's 6 months to a year out. And even though you wait a year for your case to get into court, if it's a civil case, the chances are the first time that it comes up for trial, it will get bumped because there are only a limited number of judges in courtrooms available, and all of the criminal cases that are set to be tried that day go first because the criminal defendants have a constitutional right to a speedy trial. So the civil cases only get the courtrooms and judges that are left over after all the criminal cases are either resolved or tried. But when you finally get a courtroom, or just before you get the courtroom, there will be a pretrial conference. And at the pretrial conference, the judge who's going to be in charge of the case meets with the trial lawyers, and they discuss any of that judge's particular courtroom rules about how the evidence is to be presented. They discuss any motions in limine that have been filed. That is spelled L-I-M-I-N-E, a motion in limine or limine, and it is a Latin word, and they ought to just say a motion in limiting because that's what it really is. A motion in limine is similar to what we were talking about when we talked about motions to strike in the complaint. During discovery, it may have come out some piece of very prejudicial information that has no proof relevance to the issues of the case. Maybe we discover, as we talked about earlier, that the defendant's mother was a Nazi, and they want to present evidence of that. And it's prejudicial, and it has no proof relevance to the issues of the case. And so the lawyer for the defendant will say, Judge, we want a motion in limine for an order that says there will be no mention in the trial or a presentation of any evidence in the trial that indicates that the defendant's mother was a Nazi, because it's highly prejudicial and it has no relevant proof impact. And the judge will say that's granted. And so there may be a number of those, and some may be granted and some may be denied. Now, the other thing that happens at the pre-trial conference is that we have gone over the jury instructions. Once the whole trial, the plaintiff and the defendant have presented all of their evidence and all of their opening and closing arguments, the case goes out for the jury to decide if it's a jury trial. And there are a set of written instructions that the judge reads to the jury just before he sends them out. And many of those instructions are kind of standard instructions, like you must select a foreman of the jury, and you must be respectful of everyone's opinion, and you all have to work at finding a fair result and express your opinions. But then there are specific jury instructions that are related to the specific facts of this case, like here are the required elements that must be proven to win a cause of action for negligence. And so there are pages and pages and pages of jury instructions, and as you might imagine, some of them favor the position of a plaintiff and some of them favor the position of a defendant. And so the plaintiff's lawyer gets to submit his requested list of jury instructions for the judge to read, and the defendant's lawyer gets to submit a different list, and the judge has to decide between which ones of those jury instructions that have been requested will actually be given to the jury. And so trial lawyers spend hours and hours of their life poring over these hundreds of jury instructions and then arguing that which ones should be presented by the judge. And many successful trial lawyers say they start their whole trial preparation based upon the information that is in those jury instructions. But the sad thing is we spend all those hours fighting over those jury instructions, and then at the end of the trial, when the jurors are exhausted from listening for hours or for days to lawyers and evidence, just want to get out of the courtroom and go decide the case, they have to sit and listen to the judge read this long list of jury instructions. The judge is usually very careful to read it in a monotone voice so he doesn't put any special prejudice on in favor of one instruction or another, and he reads and reads and reads these jury instructions, and sometimes you can see the poor jurors falling asleep while he's reading them, and so you have to wonder how much value they have at that point in the trial. But anyway, we decide on those at the pretrial conference, and then we're ready to begin the trial. If it is a jury trial, and a jury has to be requested by one side or the other in a civil case, or the judge decides the case. But if it is a jury trial, we bring in a panel of prospective jurors, and we swear them in to tell the truth while they're being examined to see if they would be okay for the jury. And we do what is called the voir dire, V-O-I-R-D-I-R-E, and that is the examination of the jury to determine whether they have any biases that would make them unable to render a fair and impartial verdict. Now, the voir dire with an experienced trial lawyer is a thing of art to observe. It's an amazing thing, and a master trial lawyer can win or lose a case sometimes right in the voir dire. Supposedly, they're only asking questions to ferret out any biases that the other side may have. The juror may have that would render them unable to give a fair and impartial verdict. And so they ask questions about that, but at the same time, a master trial lawyer will ask questions that they try to form some kind of bond or alliance. He may say, "Now, Mr. Smith, I see on your jury instruction form that you were in the Army. What branch of the Army were you in?" "I was in the Army." "Oh, you were in the 2nd Armored Division. Wow, I bet you did your basic training at Fort Hood, Texas." "Oh, man, I did that too. Oh, what a horrible place. You remember the dust and the heat?" And you see, hoping to form some kind of a bond, get a guy in the jury on your side. And another thing they might do is they might try, and they got to be careful about this because the judge or the other lawyer may call them on it, but sometimes they'll actually try to begin to get a little bias into the jury at the very beginning of the trial. Maybe it's a personal injury case where your neighbor slipped and fell on the crack in the sidewalk out in front of your house. And they might say, "Well, Mr. Smith, how do you get along with your neighbors? You friends with all your neighbors?" "Oh, yeah, I live in a great neighborhood, and, we're all friends." And you say, "Well, this is a case about someone that's suing their neighbor. How would you feel if one of your neighbors sued you?" And at that point, there may be an objection, or the judge may say that's not appropriate. But you got the jury thinking about, well, I'd be madder than hell if one of my neighbors sued me, and you see the damage has already been done. So that's the voir dire. And each lawyer, when the voir dire examination is over, each lawyer will have be given a number of jurors that they can challenge, peremptory challenges. A peremptory challenge, you just say, "Judge, I'd like to thank and excuse juror number 6," and you don't have to give any reason. The judge just says, "Juror number 6, thank you for being here, you're excused," and they'll put in a different person on the jury. You're only given a limited number of those, maybe 4, maybe 6. When you've used up your peremptory challenges, if there are still people on the jury you don't want, then you're on thin ice because you have to challenge them for cause. "Judge, I'd like to thank and excuse juror number 7 for cause in that he made a statement about black people, and as you know, my client is a black person, and I kind of heard that I think there's a little bias there, and they might not be able to render a fair and impartial verdict." Well, you got serious risks involved in challenging jurors for cause. First of all, the judge might say, "Yeah, I heard what that juror said too, but I don't think that would interfere with his ability to render a fair and impartial verdict, so he can stay." Wow, you just called juror number 7 a racist, and the judge said he stays on the jury now. Ooh, you got a problem with that juror. Or here's something else happens. You say, "Judge, juror number 7 said something that sounds biased, and we'd like them off the jury." And the judge says, "Okay, juror number 7, I heard that too, and it's a little iffy, and so thank you for being here, but you're excused," and you put a different person on there. But what you don't know is that during the hours that the prospective jurors were waiting out in the courthouse hallway to be called for jury duty, juror number 7 and juror number 8 found out that their kids both go to the same schools and they're both in the same parent-teacher association, and they became best of friends. And you just got juror number 7 bounced off of the jury as a racist, but now juror number 8 is madder than heck at you because he just lost his new best friend. So challenging jurors for cause, you better have good cause because there's risk to doing that. Once we finally get all the jury challenges done and the voir dire done, we're ready to start the trial. The judge swears the jurors in for a second time now, or the judge or the bailiff swears them in, so that they're swearing now that they'll render a fair and impartial verdict in the case. And we proceed with opening statements to start the actual trial.